Good afternoon. My name is Kate Shank, and I'm the Deputy Director of Legal Aid Chicago. Welcome to Legal Aid Chicago's second session of our series, Finding Solutions, Legal Aid for Our Most Vulnerable Populations. Today, we'll explore the barriers facing formerly incarcerated persons and how legal aid can help. And now to get us started, I'll turn it over to the hosts of today's session from Jenner & Block, Megan Petzel and Ann Mitchell. Megan and Ann.
Hi, everyone. I'm Megan Petzel. I'm a partner with Jenner & Block here in Chicago, and I serve as a co-chair of Legal Aid Chicago's board. It's an honor to introduce today's program, along with my partner and fellow Legal Aid Chicago board member, Ann Mitchell. First, just a few quick words about why Legal Aid's work is so important to us and our firm. Legal Aid Chicago and Jenner & Block have a shared mission of providing Cook County residents with access to justice. Legal Aid was founded on the philosophy that all are entitled to quality legal representation, regardless of income. That mirrors the mission behind Jenner & Block's pro bono program, founded in the 1950s by our partners Tom Sullivan and Jerry Solovey, two legal legends within the firm and within Chicago. They believed that every person deserved competent and zealous representation and stepped up to devote countless hours of pro bono representations, including in criminal cases like the seminal Supreme Court case, U.S. versus Witherspoon. We lost Jerry in 2011, and we just received word this morning that sadly Tom passed away yesterday. I can't think of a better way to honor Tom than to get together with all of you today to discuss a topic that he was passionate about. Tom fought relentlessly to address inequities in Illinois' criminal justice system, ultimately leading the commissions that led to the abolishment of the death penalty here in Illinois. So today, in further support of this legacy, we're committed to Legal Aid Chicago. We recently partnered with Legal Aid Chicago on training lawyers to use strategic legal and policy tools and offering criminal records relief. This crucial work removes barriers to employment and civic participation for people with conviction records. And you'll hear more about these issues today and how you can help. So to get into that, I'm going to pass things off to my colleague, Ann Mitchell, who will introduce you all to our speakers. Ann?
Thank you, Megan. Good afternoon, everyone. It's my pleasure to introduce the speakers for today's session. First is Brendan Schiller, who is a founder and board president of the Westside Justice Center. Maria Moon, who is a housing justice organizer with the Chicago Area Fair Housing Alliance. And then from Legal Aid Chicago, Natanya Pope, who is a staff attorney in the Volunteer Services Unit, Nathan Nash, who is a staff attorney in the Housing Practice Group, and Mackenzie Spear, who is an EJW fellowship attorney, also in the Housing Practice Group. And I'll turn it over to Brendan to kick us off. Thank you.
14 months into the pandemic, I still start with the mute on. Thank you very much, Ann. So I'm here to talk about collateral consequences. And the thing about that phrase is it implies that the collateral consequences are secondary. And in many cases, collateral consequences are actually the most harmful consequences of criminal convictions of all sorts and all sizes. And in fact, they're the ones that could have the longest impact, that further exacerbate already existing inequities in several areas, including education, housing, employment, and civil rights in general. And so for the practitioner, so there's just to set the general foundation for the next set of speakers, for the practitioner, for the criminal practitioner, there's a number of considerations that one must have when it comes to collateral consequences at every step of the process. Collateral consequences are different depending on the diversionary, even for things like alternative and restorative justice and diversionary courts and processes. Because, for instance, when it comes to immigration, it doesn't matter if somebody takes something that's supervision. It could impact and could lead to deportation. However, types of diversionary programs that don't lead to any type of conviction won't. That's different for other types of collateral consequences. Similarly, for the criminal practitioner, whether or not pleading to felonies and misdemeanors have a variety of different impacts in terms of potential licensing at the state level for employment and entrepreneurial opportunities, as well as in the private sector on housing, which will be discussed in more detail later, and other potential civil rights. So every step of the way, whether or not to take a diversionary and what type of diversionary opportunity for a criminal client, whether or not to plead and whether you can get a reduction to a misdemeanor versus a felony. And then even the types of sentences. There is, particularly for some of the federal collateral consequences, but other types of collateral consequences, the length of a sentence, the type of sentence, the type of conditions on a supervised release that follow a sentence, both at the state and the federal level, again, can continue to exacerbate the already existing inequalities in terms of the basic human needs and services that returning citizens need. One example is oftentimes in this day and age now with the changing laws on marijuana, you can get both state and federal criminal judges to agree to do basically time considered served or probation for big marijuana cases. But there's a huge difference in terms of the collateral consequence of time considered served with a supervised release versus a probation, which actually could lead to more impactful collateral consequences. And it's my understanding not to get into too many specific details, just to kind of lay the broad foundation for the rest of the speakers today. So I just wanted to go over all those various areas that the day-to-day practitioner needs to be aware of. When it comes to policy, there is a lot of opportunity at Springfield, in Illinois, to really begin to change these collateral consequences. Most of the recent, very impactful criminal justice reform has focused on things like police reform, police accountability, bond reform. There was a couple of years ago, one attempt to, led by the Safer Foundation and others, to remove some of the collateral consequences. There are still 54 types of state employment licenses that are not available to certain people based on criminal convictions.
Thank you, Brendan, for kind of giving us an overview. It's really an important topic, and we're going to talk a little bit more about it, and I appreciate your input on that. So the work that we do in civil legal aid is impactful for people who have had some level of involvement in the criminal legal system. And what we mean when we say involvement, we're talking about arrests, non-convictions, which mean that there was a case that where there was no finding of guilt. We're also talking about convictions and also incarceration. So every arrest, prosecution, and conviction creates a record that does not automatically go away. And as long as these records are discoverable, it subjects people to those collateral consequences that Brendan talked about, which we also call permanent punishments. And we call them permanent punishments because it's a little bit more descriptive of the type of effect that it has on people's lives. So permanent punishments are civil legal punishments that people face even after their involvement with the criminal legal system has ended. And we call them this because it's a good way of thinking about those long-term effects. They are long-lasting, and they show up in a system of laws, policies, and regulations that often permanently restrict someone's access to many civil rights that people without criminal records may have, like employment, housing, education, and other opportunities. In Illinois, there are 3.3 million adults alive today who've been arrested or convicted of a crime since 1979. And to put this into more context, Illinois has a population of just over 12.5 million people. And this means that a quarter of all people in Illinois have some type of criminal record. And these people, when their involvement with the criminal legal system is over, they have more than 1,000 unique permanent punishment laws waiting for them when they're done with their criminal case. So while we're going to talk about how criminal records affect access to housing a little bit later, a majority of these permanent punishments specifically block access to employment. So it's always important to understand the role that structural racism plays across systems that our clients have to navigate. So especially in the criminal legal system, that racism carries over to permanent punishments when we look at the disparate impact that these restrictions have on Black and Indigenous communities of color. And we understand that structural racism is basically how biases on race and ethnicity play out across institutions, especially when those biases are compounded. But how does this look? So this graphic shows us that Black comprise only 13% of the population in Illinois. However, they make up 30% of the people who are arrested, 35% of the people with convictions, and almost half of those in Illinois who have felony convictions. So when you think about this, consider the long-term impact that criminal legal system involvement has on these communities, factoring in the permanent punishments on the individuals who live in them. And barriers to opportunities, we know that it correlates to recidivism and generational involvement in the criminal legal system. And this in turn causes entrenched cycles of violence and poverty within families and in communities. So this is why the work that we do is so important, because helping people clear their criminal records removes those barriers put in place by permanent punishments. So not only is it impactful from a racial justice and civil rights standpoint, it really does change the trajectory of people's lives and that of their families, and then building out to their communities. So to understand how clearing someone's criminal record is vital to removing those barriers put in place by permanent punishments, it's best to start at the beginning. What is a criminal record? How is a criminal record created? And in a nutshell, a criminal record is created whenever someone is arrested. Now that person doesn't need to go to court or need to be found guilty in a case. And when we're thinking about criminal records, we are pretty much thinking about two types. We have juvenile records and adult records. Now for juvenile, it typically involves arrests in cases that happen when someone is under the age of 18. And what happens to those records are governed by the Juvenile Court Act. In terms of relief that are available in juvenile cases, we have automatic sealing, which happens in every case, which means that the general public can't see them, they don't have access to them. However, juvenile arrests can show up on some background checks. And then as far as expungement, almost all juvenile cases are eligible, juvenile offenses are eligible to be expunged. Now, when we think about adult records, those are.
This is Carol.
So when we're talking about adult records, we are talking about arrests in cases that occurred when someone is 18 years or older. And what happens to those records are governed by the Criminal Identification Act. In terms of relief available for adult criminal records, we have expungements for arrests and offenses that did not result in a conviction. However, convictions can only be sealed if they are eligible for such relief, because there are a number of offenses that are never eligible for relief, like minor traffic offenses, DUIs, domestic battery, some sex offenses, and animal abuse offenses. So I just want to take a moment now to just pause and talk about the difference between non-convictions versus convictions. And it's important to distinguish them because it determines what kind of relief that somebody is able to get. So in working with our clients, we may see many misconceptions on a daily basis about whether or not someone's convicted or not. A lot of people don't know. Convictions usually mean that there was a finding of guilt, but it's not always apparent. And an easy way to know if the case resulted in a conviction is by looking to see what the sentence was. So there are certain types of sentences that mean that indicate that there was a conviction. So it's not just that a person has to go to jail or prison. If you received a fine in your case, that's a conviction. Probation, even supervision that where you didn't satisfy the terms of it, those are all convictions. Interestingly, for juvenile cases, findings of guilt, we don't call them adjudications. The law doesn't consider them, we call them adjudications. The law does not consider them to be convictions because the law wants to take into account that children are still developing and they want to treat them differently than we do adults. And in part to remove the stigma faced by adult criminal activity. So when it comes to the work that we do, the bulk of our criminal records relief is helping people with either expungement or sealing. Although we do offer help with other types of relief, most of it's going to be either a case can be expunged or sealed, and that's the bulk of our clients. And the distinction between expungement and sealing is an important one to make because it affects the way that a criminal record could show up. Now, expungement, like I said before, is available for non-convictions. And what that means is that arresting agencies destroy the records as if the incident never happened. If the arrest led to a case, then the clerk impounds the file and the record is only available in the future by court order. And most importantly, for expungement, no private or public entities can see those records. Now, for convictions, getting a record sealed is the only available remedy. The general public can't see the case information, but it's still available to law enforcement agencies, and no private or public entities can see sealed misdemeanor convictions, but sealed felony convictions can still be seen if they do a fingerprint-based background check. So for instance, if you want to work at a school or nursing home, bank, or the airport, and you got to get your fingerprint scanned, then those sealed convictions will show up. And the takeaway is that expunged records will not show up on a background check, but sealed records might. For people whose records cannot be expunged, sealing can be just as effective for the purpose of getting a job with a private employer. And expungement and sealing, even though they're the most recognized and effective forms of criminal records relief, they might not be available for everyone. So what we try to do is explore all the options for our clients. And we really do need to take it on a case-by-case basis, taking into consideration what their specific goals are and work with them on getting the type of relief that's available to them. So let's go back and revisit permanent punishments. We know that most of them interfere with someone's ability to get a job. So how does that happen? So how it shows up for us is that many of our clients come to us after a prospective employer has run a background check and then there was a hit, something came up. And it really does depend on the type of background check. Whatever comes up, whatever the prospective employer sees or the landlord, it depends on the type of background check that they run. It was fingerprint based, or they just did a public database search, whether or not the record was expunged or sealed, whether it was a juvenile or adult record, and generally boils down to who can access that information. Now, how these records can come up can be complex. And again, we look at them on a case-by-case basis, especially as it applies to housing, as we'll talk about later. Employers and landlords often use companies that are in the criminal background check business to get information on clients. And often this information can exist on third-party websites that people are not even aware of exists. For instance, we had a former client who we helped expunge a record, who called us because his mugshot was on a website years after the record was expunged. And I'm not sure how he found out. Maybe he Googled himself. I've been known to Google myself before, but anyway, he found his mugshot. And we were able to help get the mugshot removed by providing him with the expungement order, which he had to show the whoever administered the website. So this is just one example of how we're able to help remove barriers for our clients who have criminal records that they consistently face. So I just want to talk a little bit about what's known as the second chance gap. And we've experienced this in our work consistently. So the second chance gap describes a trend that was reported on in a Michigan Law Review article that was published last year. And the article talks about the widening gap between the laws that have expanded eligibility for criminal records relief and then the ability of the people who are eligible to access that relief. So effectively, it is the difference between eligibility and the delivery of a person's second chance. And to give this a little bit of meaning, Illinois was ranked #1 in the nation for having progressive laws that are designed to restore civil rights for people who have been involved in the criminal legal system. Now, this report also came out in early 2020, and it looked at restoration laws across 9 areas, including voting, employment, and criminal records relief. And the ones that are shaded red they deal with criminal records relief broadly, right? There's more than just expungement and sealing. And again, while we work mostly on expungement and sealing, what this report card shows and what this ranking shows is that we really do have a strong foundation in the law to be able to help our clients. Now, how the second chance gap comes into play for us is that in our state, of all the people who are eligible for some form of criminal records relief, only 11% actually benefit from it. And the reasons why this happens, we encounter on a daily basis in our work with our clients. It can be misunderstanding of the law as it should be applied, and this misunderstanding carries through at the level of the clerks, the judges, the police, state's attorneys. At the criminal trial stage, judges and public defenders may not consider or understand the permanent punishments that are waiting for people when their sentence is over. There is a stigma of any type of criminal legal system involvement, as we know when we talked about the structural racism that pervades that system. And anything from costs, the cost prohibitive nature of expunging or sealing your records. It costs money to file in each district a person is arrested in, and Cook County has 6 districts. So you have administrative failures of the system. Also, the length of time that it takes for an expungement or sealing case to make its way through court can be staggering. In District 1 in Chicago, after filing, sometimes we're not getting responses for up to a year or more. So this is a lot. It definitely is an access to justice issue. And the result of that is that there's a failed trust of the system in these communities who've long been affected by these failures of the system. So our work is focused on establishing trust for our clients, but we know that we still have to work within these systems to remove barriers. And even though with everything that's put in place, we can't guarantee that there'll always be a successful outcome, we really do work hard to keep them from falling into the gap. And to do this, we spend a lot of our time proving that they are good people who deserve a second chance, given all of that we have to work against as far as how the system works and how it moves and the different players within it. This work can be daunting, but it's work that we have been doing and will continue to do on their behalf until their rights are restored. So just to give some examples, a couple of stories that from our clients that really do exemplify the second chance gap. So we see that sometimes there's administrative resistance to criminal records relief. And the way that this shows up is pushback from arresting agencies even after receiving an order to expunge. So the story of Jason is, he was one of our juvenile clients whose mom called us because his arrest record came up after his case was dismissed more than a year ago. And the law says that when a juvenile case is dismissed, it is to be automatically expunged. And in this case, that did not happen. Mom found out about the existence of this arrest record by filing a Freedom of Information Act request for them a year after the case was dismissed, and the arresting agency still had all the documents related to Jason's arrest. Now, Jason, he had an attorney in his underlying juvenile case, so they were able to track down that automatic expungement order, which means that we have to file it. But one of the ways we make sure we can provide the best service is by communicating with agencies like police departments to understand why some of these things happen. And you'd be amazed at how little of an understanding of the law that many people who have these records actually have. So another example of resistance is when, and an assistant state's attorney or a judge misapplies the law. So Ronald is one of our adult clients, and he was consistently held back by his criminal record. So he had non-convictions. Now remember, non-convictions means that there was no finding of guilt and they can be expunged. And his case languished in court for months because the state's attorney objected on the basis of public policy. The judge also would not grant the expungement without a letter of reference from an employer and until Ronald actually appeared in court. Remember, a non-conviction, again, it means that there is no finding of guilt. So in cases like Ronald's, where you see this type of pushback, it's as if the system is civilly punishing people for something that they were not even found guilty of. So this is a way that we see that this stigma followed him because of these extra barriers that the judge placed and the state's attorney placed on him. And all he wants to do is just move forward in his life. Those records made it hard for him to find stable housing. It was difficult for him to find employment. He finally got a job where he worked 60 hours a week. So it wasn't easy for him to attend court, yet his expungement was held up until he did. The good news with Ronald is that the expungement ultimately was granted, and now we're helping Ronald find secure housing. So even with the most progressive laws in the country, Ronald's story shows that there are still many obstacles for people, and it's a great example of how we're closing the gap for our clients. So hopefully I was able to provide some general context of how having a criminal record impacts a person's access to civil rights that most people enjoy. As an agency, we help people resolve many civil legal problems. And I guess the takeaway is when you factor in the existence of permanent punishments, the very existence of a criminal record really is at the root cause of most of the legal issues that we help our clients resolve on a daily basis. So I'm supposed to read the code, and I'm going to do that. And just to remind you that the link to the survey is in chat. So before we get into ways that the criminal records, the existence of criminal records impact access to housing, anyone who wants to get CLE credit for this webinar, go ahead and click on that link, and the code is displayed here, but it's blocked by my chat. Let me see. Okay, so 9512 CLA, 9512 CLA. And so now I'm going to hand it off to Maria Moon, who is a housing justice organizer at the Chicago Fair Housing Alliance.
Sorry. Hello, thank you so much. Hello, can everybody hear me?
You're good, Maria.
Okay. Yes, so and thank you for that presentation on expungings and ceilings. My name is Maria Moon. I am the housing justice organizer with Chicago Area Fair Housing Alliance. I was a part of the passing of the Just Housing Amendment, Chicago Area Fair Housing Alliance, along with so many great organizations. Most importantly, though, I always like to say that, you know, we are so grateful to those who were directly impacted, who spoke, who told their stories, who fought for this ordinance to be passed. We are open at CAFA to do Just Housing Initiative presentations. Because of COVID, we have definitely become a referral system, a part of the referral system. So we are currently, especially I myself and our community navigators, who are also directly impacted people themselves. We work on a daily basis. Actually, I'm having a referral call, call me as we speak on this Zoom call. But we work with people that's directly impacted by housing, domestic violence in housing, immigration and housing, records and housing, whatever, whatever has to do with housing. So me, myself, I was, directly impacted by this, as I said, living out my cards, couch surfing, in dangerous, unsafe situations, because of these permanent punishment, these collateral consequences. Which I wrote a spoken word piece about permanent punishment and collateral consequences. I heard it said a whole lot of times here. I was very pleased using the term, because that's exactly what it is. It's just not true justice. It's not fair to have a person to complete a sentence, a jail sentence or prison sentence, and then punish them for life. I've worked on various bills and ordinances and legislation since I've been out. I've been out now for, I believe, almost 8 years. And, I've seen people who have passed away who have worked on these bills and legislations with me, that have passed away homeless, still, who have been out of prison for 10 years. So I am truly definitely proud to be a part of the passing of the Just Housing Initiative. This is definitely a great and honorable work, as far as the panelists is represented today, all the organizations that's represented. I thank you all for caring about this work, which simply means caring about the people. Understanding and acknowledging that, that people should not be punished forever for the rest of their lives, for being justice involved. So again, if anybody wants any JHI presentations, I'm here. That's pretty much what I do. We do PowerPoint presentations. We created a video called "We Are Not Our Records" that speaks the voice of those who are directly impacted, have been directly impacted by housing, as far as having a record. So just reach out. My information is mmoon@CAFA, CAFHA.net, and we will be willing to do presentations with community organizations, realtors, property owners, landlords, most importantly, people directly impacted.
Thanks so much, Maria. So the campaign Maria was a part of, I want to give some context to it. Maria is one of our partners at the Chicago Area Fair Housing Alliance that was instrumental, along with other impacted individuals, in getting this protection passed in Cook County. So I want to connect Maria's story about, folks who had been sleeping outside, sleeping in their cars because of a criminal record, to some of the historical legacies of segregation in the city, but also kind of the present day discrimination that Maria was describing. So as you all know, we live in one of the most segregated cities in the country. I think this happens because of many different layers of discrimination. The individual bias that Maria was talking about when it comes to renting to folks who have a former arrest or conviction record. At the policy level, it's the state barriers that Brendan and Natanya described. And then at the institutional level, Maria and our housing practice group, work with housing authorities who screen for arrests and convictions before letting folks have a housing subsidy in the city. So this all adds up to that second chance not really being a lived reality for the folks that Maria was organizing with to get the Just Housing Amendment passed. When I talk to clients about leasing up in Chicago, finding an apartment, oftentimes they say they wanted to move to a neighborhood that was closer to their work, maybe public transit, a safer school or block for their kiddo. And those conversations often start with, I qualified for this apartment, but, and you can fill in that blank with an arrest or a conviction, a public record of an eviction filing, or using a housing choice voucher to help pay for rent. So I think the Just Housing Amendment, which I'm going to cover the basics of next, is a great example of the organizing to make our city a more just city, empowering people who have been directly impacted to stand up for their rights to something like housing, and creating some clear anti-discrimination provisions that allowed civil legal aid attorneys and other advocates to enforce the protection. So the basics of the Just Housing Amendment are that it prohibits housing discrimination on the basis of arrest and conviction records in Cook County. It went into effect on February 1st of 2020. So just before the pandemic hit, I think we have work to do, and Maria's talked about doing that important work of raising awareness of this new protection. It broadly prohibits discrimination in any real estate transaction based on covered criminal history. What we're going to focus on today is apartment rentals, because the housing practice group here at Legal Aid Chicago mostly works on the rental properties, whereas our consumer practice group would do more home ownership issues for low-income Chicagoans. So there are kind of two protections I want to emphasize when it comes to the Just Housing Amendment in the context of renting apartment units in Cook County. So there's a substantive protection now, or what can be considered on an application when it comes to arrests and convictions. And there's also procedural protections, or when and how these arrests and convictions can be considered. The big major change, substantive change, is that there's a new prohibition on considering arrests, convictions, and juvenile convictions, and convictions that are 3 years or older. So it essentially creates what we call like a 3-year look back period for our convictions in Cook County on an apartment application. There is a carve out for policies on registering for relevant sex offenses that the JHA didn't change, which I'll just note. The procedural protection is that there are kind of two parts to that. With convictions from the past 3 years, there needs to be an individualized assessment of those convictions. And it requires the reviewer, the JHA requires the reviewer to pre-approve an applicant before running a background check. So a reviewer of an apartment application should be looking at financial qualifications, things like current income or credit history, and also a tenant's history. For example, a reference from a former landlord before they even ask about or arrest their convictions or run a background check. So in practice, this creates kind of a 3-step process that's the new norm in Cook County. We see small landlords do this themselves, paper application and run a credit check, and then a more mid-sized or large property management company running this through a third party. Everyone in Cook County needs to follow these processes now under the JHA. So the first piece we talked about, mandatory pre-clearance, that refers to the reviewing of financial requirements and tenant history prior to asking about arrests or convictions. Step 2 would be this optional background check. The JHA doesn't require that a background check is run or that a reviewer asks about arrests or convictions, but it does create obligations if the reviewer chooses to use that as part of their screening. So the reviewer must demonstrate that a conviction in the 3-year look-back period supports a finding that a denial on a criminal conviction is, quote, necessary to protect against a clear risk to personal safety and or property. So reviewers have this obligation to do this individualized assessment instead of relying on personal assumptions about what involvement with the criminal legal system means about a person or any biases about general contact with the criminal legal system. Again, we would know involvement would be predicted by race, income, and neighborhood. So this is really a protection against a racial bias as well. The third step opens kind of a conversation between the reviewer and the applicant. So the applicant has the right to ask for a copy of the background check that the landlord is relying upon, and the landlord has to provide that within 5 days. Then the applicant has an opportunity to dispute the accuracy or relevance of the record. So in addition to pointing out errors, they can provide what the commission calls evidence of rehabilitation. In other words, anything that reflects that they wouldn't be a risk to safety or property. So give some context to the conviction. And then that should happen within 5 days. And the next step would be for the reviewer to issue a written decision based on that dispute. So they have to, within 3 days of receiving the dispute, respond in writing. So both the substantive and procedural aspects of this makes advocates clear partners and civil legal aid attorneys clear partners in doing this enforcement work, especially with a written denial. It makes our job a lot easier to show that someone was discriminated against. So we're working with others in Cook County, including Maria at CAFA, to help applicants take a few steps. The first is to know their records. So working with our team that works on expungements to request a record, a rap sheet, clear their records as Natanya and her team is working on, and then to know your rights when it comes to housing. So what does an unlawful denial look like, and what are the dispute procedures, and when should those be implemented? So 5 days to request and provide a record, 5 days to dispute or contextualize that record, and 3 days for the landlord to reconsider the denial and issue a written statement or a determination. The final protection I just want to highlight in the JHA is the protection against discriminatory advertising or communications. I think this is key for our clients because often they just feel discouraged from applying to apartments in certain neighborhoods or with certain property managers, hesitant to lose application fees. It can be a risk. So both of these advertisements are from Craigslist in April of this year, so well into the JHA's implementation later. And on the top, you see no eviction or felony history. And then on the bottom, you see an ad that says, it provides the name of the JHA, the new law. It says some specifics about the process, and it notes evidence of context and good tenancy will be considered. So I think this does a good job of showing and highlighting how debiasing the application process is also part of protecting tenants' rights here. I think of the first no eviction, no felony history as the "you're not welcome here" warning to our clients who are predominantly people of color and may have had involvement in the criminal legal system. So I'm going to turn it over to Nathan, who is one of our fair housing attorneys, who will talk about 2 clients we've helped support and enforce their rights under the Just Housing Amendment and how that connects to broader fair housing issues.
Thanks so much, Mackenzie. So like Mackenzie said, I'm going to start by talking about 2 clients we worked with who were impacted by the Just Housing Amendment, and then our broader fair housing work generally and how this fits in. So the first client I want to talk about is Mr. Woods. Mr. Woods was experiencing homelessness and was referred by the Chicago Housing Authority to a subsidized apartment with supportive services in northern Chicago. And at the outset of the COVID-19 pandemic in March 2020, Mr. Woods applied for the apartment, submitting his rental application and background check simultaneously, which, as Mackenzie said, is already a problem because those are supposed to be processed first. The tenant is supposed to be approved, and then there's a background check allowed under the Just Housing Amendment. Nor did the landlord ever give Mr. Woods a copy of the application criteria. Nonetheless, the landlord denied Mr. Woods on the basis of, quote, criminal history, without specifying what criminal history or how it made Mr. Woods not fit the landlord's application criteria. Mr. Woods attempted to follow up with the property owner and was unsuccessful. And that's when Legal Aid Chicago became involved. And we helped Mr. Woods get a copy of his background report, which showed that the only conviction within 3 years, which, as Mackenzie said, it's the only time frame under the Just Housing Amendment that landlords can even look at, was for misdemeanor retail theft while Mr. Woods was experiencing homelessness. So we got involved. We helped Mr. Woods advocate and convince the landlord that they were not meeting their burdens under the individualized assessment. And eventually the landlord reversed the decision and Mr. Woods was able to find housing. So I think this case shows the importance of an individualized assessment and why denying someone just because of misdemeanor retail theft while they're experiencing homelessness has no bearing on their qualifications as a tenant. And so the next client that I want to talk about today is Mr. Skinner. And it's a little bit different than and it emphasizes why it's important to talk about only arrests within that 3-year period, like Mackenzie was saying. So Mr. Skinner served a 10-year federal sentence and got out in 2020. He was living in a halfway house in Chicago and was looking for an apartment where he could reunite with his teenage children. He applied for housing in the Wicker Park neighborhood. The landlord asked him about his conviction history. Mr. Skinner was upfront, said he'd served a 10-year federal sentence. And then Mr. Skinner submitted his application. And to surprise, the landlord called him the next day and said, "I'm denying you. I did a Google search, and I found that there's an unsolved homicide, and you're one of the suspects. And even though you were never charged, never convicted, never arrested in connection with that, the landlord said, I don't want you living around families in the apartment," which caused Mr. Skinner to apply for us for services. We wrote a letter. Mr. Skinner understandably no longer wanted to live in that apartment if that was the landlord's attitude. But we were able to help Mr. Skinner get some financial compensation, compensate him for the time that he spent applying for the apartment, his application fee, and fortunately he was able to find another landlord in pretty short order and move in with his children. But the Just Housing Amendment, prohibited back at an unsolved murder from 2004, even if Mr. Skinner was arrested or there was any kind of judicial proof at all, but here there wasn't even that. And the Just Housing Amendment, really restricts what landlords can look at just to that narrow 3-year window. And so these are just a few of the clients that Housing Practice Group successfully helped under our Fair Housing grant. And I just want to take a minute to talk about the Fair Housing Act and how this work fits into our efforts. So the Fair Housing Act was passed in 1968 thanks to the tireless advocacy of Dr. King and other civil rights activists. And it prohibits refusing to rent or otherwise discriminating against tenants because of a protected characteristic, which as you can see on the slide, includes race, color, religion, sex, familial status, or national origin. And importantly, Fair Housing Act prohibits both facial discrimination, where a landlord says, I'm not renting to you because you have children, but also prohibits policies that seem facially neutral, where they don't explicitly say, I'm not renting to you because of a protected characteristic, but where there's a policy that, even though it doesn't say that, that's how it operates in practice. And we think, discriminating against tenants because of prior arrest or conviction is one such policy. So I want to talk a little bit about that second category of liability, which is called disparate impact liability. Even though the Fair Housing Act was passed in 1968, it wasn't until 2015 that the U.S. Supreme Court recognized that the Fair Housing Act allowed for disparate impact liability. And for those keeping score at home, the decision was Texas Department of Housing and Community Affairs versus Inclusive Communities Project. Now, I'm simplifying it a little bit, but to prevail on a disparate impact claim, a plaintiff must do pretty much two basic things. One is to show that the policy, for example, discriminating against someone because of a prior arrest or conviction, disproportionately burdens a protected class. That's kind of a statistical showing that if you're not going to rent to anyone with a prior arrest or conviction, you're more likely to disadvantage, people by POC or a certain race or sex. And the second thing is to show, if you show that statistical disparity, is to show that the policy is not necessary to achieve a valid interest. And that can be because the policy has nothing to do with a renter's qualifications, or it can be that the policy is just too broad. You don't, in this case, you don't necessarily need to screen out everybody who has a prior arrest or conviction. That's not necessary to get renters who are qualified to live in the building. And so I want to look a little bit more at how this disparate impact liability works in criminal records. Like Natanya said, by POC are more likely to be, suffer an arrest or conviction. And we know that's how, unfortunately, the criminal system works. And that having a policy that anyone with a prior arrest or conviction, no matter what, will disadvantage by POC tenants disproportionately than other tenants. And we also know that automatically rejecting every tenant with a prior arrest or conviction has no bearing, no matter the reason for the arrest or conviction, no matter where it falls within that 3-year window, no matter, like Mackenzie said, the references that someone can give that they're a great employee, that, they're active in their community or in, religious community, no matter any of that, it's just an automatic denial. The example given by HUD in their guidance on this is someone with a minor traffic offense has no bearing on someone's qualifications to be a tenant. I would argue that Mr. Woods's conviction of misdemeanor retail theft while experiencing homelessness has nothing to do with his qualifications as a tenant, and his ability to get a new chance in housing. So this is thinking through. We think that disparate impact liability fits well with discriminating against people with prior arrests and convictions. And as Maria said, the impact of discriminating against someone can be severe. It can mean the difference between homelessness and the ability for a fresh start. And I just want to conclude by saying that this fair housing work is just one with people with prior arrests and convictions, just one of the many areas of work our housing practice group's fair housing team is doing. Our project is focused on sexual harassment in housing, which, given recent judicial decisions and guidance, includes discrimination against people because of their sexual orientation or gender identity. We also do a lot of work with disability discrimination and helping tenants achieve reasonable accommodations, whether it's a parking spot in front of their apartment or living with an assistance animal. We also help with source of income discrimination, which again, while not facially discriminatory, saying I'm not going to rent to anyone with a housing subsidy often has a disproportionate impact on BIPOC. And again, like I said, we're interested in discrimination against people with prior records, which can include arrests and convictions, but it can also include prior evictions, just because someone was evicted, 3 or 5 years ago for no reason at all, or for not paying rent, but now they have a housing subsidy, has really, again, no bearing on whether they're qualified as a tenant. And just to reiterate, we consider both facial discrimination, which unfortunately still happens, where landlords expressly say, I'm not renting to you because of children or because of your disability. But we also consider disparate impact cases, those cases that seem neutral, but actually do have a real disadvantage on BIPOC and other protected classes to be instances of discrimination under the Fair Housing Act. So thank you for listening to all of us. And I want to pass it on to Melissa, who will talk more about our pro bono opportunities.
Well, thank you so much, Nathan. And over the past year, so many of us have felt compelled to do something to address structural and systemic racism. And I'm so proud to work alongside you, Mackenzie, and Natanya to address these issues in concrete ways. And I'm so grateful for the partnership of people like Brendan and Maria. And for those of you who are feeling so compelled to help address these issues, you can do so with us. We have a variety of volunteer opportunities at Legal Aid Chicago, including providing, and in most of which provide direct services to our clients. Our volunteers work with us and we can provide comprehensive support in each of our projects. Natanya spoke specifically about options for criminal records relief, and the client demand in this area is significant. And the only way for us to meet this demand is to utilize volunteer attorneys. Attorneys can assist in the preparation of petitions for both adult and juvenile records. Legal Aid Chicago does all of the eligibility determinations, court filing, and court appearances. You can assist by completing documents and counseling the client briefly and helping them understand the process. These are short-term, paperwork-based engagements, but the impact on clients is so substantial, clearing the way towards stable housing and employment. Over the past year, we have placed over 200 cases with volunteers, including our friends at Jenner and Block. And I'm thrilled to report that we are successful in clearing the records of over 90% of our clients. So you can check out at our website for a listing of all of our volunteer opportunities, and you can also sign up. And I'm also happy to discuss with you any further interests you may have. But I do hope that you will join us in this very important work. And now I'll turn it back over to Kate Schenk.
Thank you, Melissa. And thanks so much to Brendan and Maria, our partners, and to Natanya, Mackenzie, and Nathan for your terrific presentations. So this concludes the planned content portion of today's presentation. And in a moment, we'll start the Q&A portion. Before we start that though, quick reminder, we'd appreciate it if you could fill out a brief survey about the presentation. So again, you can do that whether or not you're seeking CLE credit. And to do that, you'll click on the link and in the chat, and then you can fill out the form there. And then there's also the code if you're seeking CLE credit. So please note that if the certificates of attendance will be sent out within the next week of attending. Please join us also next week for our session discussing the needs of seniors. So the panelists will remain on to answer your questions. And if you have additional questions, you can type them into the Q&A at the bottom of the screen. And we already have some questions that have come in. That's terrific. So I'll ask Melissa to take us through the Q&A, please.
Wonderful. Well, we do have some really good questions, and hopefully we can get to all of them. So Natanya, can you talk a little bit about the effect of having an expungement? So for example, does expungement relieve someone from all collateral consequences?
The lawyer answer to that is it depends. And it really does depend on what you're trying to do. In cases like for immigration, expunging a case can actually be, a hindrance to you if you are trying to get citizenship. But for the most part, it's called a relief or a remedy because it does just that, removing the existence of those records so that most of the people who, will allow you to be able to move on with like employers or housing, getting those services, even public benefits, removing those records will actually help you do that because then they won't be able to see them.
Wonderful, Natanya. And so Mackenzie or Nathan, can you talk a little bit about the remedies? For example, if someone is denied housing, can a landlord be forced to rent to a person if it's proved that they violated the Illinois Fair Housing Act?
Yeah, I can start and then Mackenzie can jump in if she has anything to add. So the law allows for both damages, which is monetary relief, or injunctive could be forcing the landlord to rent to someone. The entity that enforces the Just Housing Amendment is the Cook County Human Rights Commission, which sometimes moves faster or slower. So there's a question whether we could get in front of them in time to convince them to rent the apartment to our client. But technically it is available. It's just a matter of that advocacy. And often we've found that contacting the landlord as soon as possible after the denial, while the apartment is still available, often through that informal advocacy, which is what happened in Mr. Wood's case, that's possible for sure. And which is why it makes it so important to have tenants know their rights and to apply for our services or to contact Maria at CAFA, as soon as they think that there's a violation of the Just Housing Amendment, because only by getting in there as soon as possible can we make sure that the tenant could potentially get into that apartment before it's rented to someone else.
Thank you. And so just relatedly, you mentioned fines. I mean, what are the range of fines or damages that you've seen? Do you think that the landlords are being forced to pay enough to encourage future compliance?
Yeah, that was something we addressed in Mr. Skinner's case. That was part of our thought. The Cook County, the Just Housing Amendment and the Cook County Human Rights Ordinance doesn't prescribe a certain level of damages. It's limited to there's punitive damages and also compensatory damages. And in that case, I can't get into the specific amount, but it certainly compensated our client for what he paid for, an application fees and the fee for the background check. But then also there was something additional on that. I think it was, around 1 month's rent plus our fees. Because the Cook County Human Rights Ordinance allows a prevailing attorney to obtain the fees. And so we think, together with charging, the 1 month's rent plus the application fee plus a portion of our fees, is hopefully enough to ensure compliance. And I think in addition, it was a good, education for the landlord. It sounded like the landlord was not aware of this law before we were involved. So hopefully, just by paying the damages, but also just our advocacy around it. Hopefully this won't happen with this landlord again. Hopefully, at whatever meetings landlords have, word will get out about this, and there won't be as many kind of flagrant abuses.
Thank you so much. And so, Natanya, we hope this is an easy one for you. Does Legal Aid Chicago do expungements or sealings, and can you talk about if we charge any fees?
Absolutely, yes. This is easy. Thank you. So we do expungements and sealings both for criminal records and adult records, and also for juvenile records. And the way that looks for criminal records is right now it's a it's a pro bono project, part of volunteer services unit. So a lot of the work that is being done there as far as drafting petitions is done by our pro bono volunteers. And for the on the juvenile side, we actually do run the juvenile expungement help desk, which is an in-court, court-based help desk. We've been virtual though, so the work hasn't stopped, even though the juvenile courthouse has been closed. We've been doing it remotely. And if there are fees, no. I mean, we are a civil legal aid provider. We're a nonprofit, so we do help everyone if they fall within a certain income limit, but often, depending on the type of case, even if they exceed, we try to figure out ways to be able to help folks. So we don't charge fees for expungement. And those associated fees that I talked about earlier with filing for expungement or sealing for adult records, because people, the people who we work with, they use our services, those fees are waived for them.
Thank you so much, Natanya. And just to reiterate, we can take referrals for expungement or sealing. You are welcome to refer clients to us. And the easiest way for them to get through is to call 312-229-6071. And of course, we do require people to have a rap sheet so we can analyze their record, at least for the adult side. So we are taking referrals. We would love to receive your referrals, and we help somebody as long as we can do something for them. At the very minimum, provide advice, of course, with the help of volunteers. So thanks, Natanya. Nathan, this is a question for you. So a very astute viewer says that the Texas Department of Housing and Community Affairs versus Inclusive Communities Project, Inc., which you mentioned, was decided by a 5-4 vote before some recent appointments to the Supreme Court. So do you have any sense of whether or not the Supreme Court might take up a similar case and potentially overrule that decision?
Yeah, well, I don't want to speculate on what the Supreme Court would do, because I'm sure I would be wrong. I will say that, this wasn't a constitutional decision. This was a decision interpreting a statute, the Fair Housing Act. And the way the court interpreted the Fair Housing Act and the Texas decision was in line with how it interprets Title VII. So, given that it's in line, and the Age Discrimination and Employment Act, I think, and given that it's in line with those precedents, and given that it's a statutory, not a constitutional decision, I don't want to predict anything, but I doubt that there would be much, there would be much likelihood of it being overturned, just because usually statutory interpretation decisions have kind of a greater stare decisis power than constitutional decisions for whatever reason. So I think it's good to rely on, basically.
Wonderful. Well, look at you, a Supreme Court nerd. So there's a couple of questions related to cannabis, which is a very popular topic. So the first is related to the recent proclamations about cannabis expungement, and we've all seen some stories in the news about J.B. Pritzker taking some action. And so, Natanya, can you talk a little bit about sort of whether or not automatic expungement is taking care of all marijuana convictions, just sort of generally?
So some of the relief that's available, because these are convictions, so we have to so in terms of the cannabis convictions, what's available is to vacate that conviction. So that's something that's available, but again, we're up against a lot of the administrative kind of setbacks that it takes to actually do this, and how long it takes for these petitions to be reviewed and sort of make their way through the court. But as far as relief is concerned, generally it is available for people who have those types of conviction.
Great. And can you answer about how somebody can see whether or not someone has actually gotten their record expunged? How can they find out? Because my understanding is there's been a little bit of issue with communications on some of those automatic relief.
Absolutely. I mean, there are a number of ways to do this. You could actually go and just get your rap sheet or request a rap sheet, and Chicago police or the arresting agency will let you know after your fingerprint is scanned whether there are records for you. Typically though, even with automatic expungement, the Illinois State Police, and you kind of have to understand who has access to these records, like when the automatic expungement is ordered, who gets that order and what is it that they have to do? And it's usually the arresting agency and the Illinois State Police. FBI also has a record of it, but the FBI gets their information from the Illinois State Police. But even with these automatic expungements, typically the Illinois State Police will send out a confirmation of the expungement. And really that's the only way, is if you actually go and try to request the information yourself. And if nothing pops up, it's been expunged.
Thank you so much. Sort of turning back to housing for a second, Mackenzie and Nathan, can you talk about penalties against landlords for flagrant violations of the just housing ordinance? Excuse me, fragrant violations would be something different, but let's talk about flagrant violations.
Yeah, I can start, and then Mackenzie can jump in if I'm misrepresenting anything. I think the flagrant violation, I think there's the potential for punitive damages under the Cook County Human Rights Ordinance. That's really up to the commission on whether they want to assess that in terms of if the violation is flagrant. There are also compensatory damages. So if the violation, no matter really how flagrant or fragrant, if it causes the tenant to lose out on a housing opportunity, which perhaps makes them lose a housing choice voucher, or a valuable housing subsidy without which they couldn't afford housing, the damages could be quite high, just speaking in terms of compensatory damages. But that's really, there haven't been too many just housing cases before the Cook County Human Rights Commission yet, so we're still kind of waiting on how that will shake out in practice. But again, I would just emphasize, the violations become more flagrant as more people are aware of the Just Housing Amendment. So I think the most important thing at this stage is just to increase education, both among landlords and tenants, that this law exists and what its protections are, and how to enforce their rights if they're not observed.
Great. And Ms. Hania, can you talk a little bit about recreational marijuana in terms of what you can possess legally right now, which is sort of fun? And then if Nathan or Mackenzie has anything to add on the rights of subsidized housing residents, that would be helpful.
Sure. So as we know, this state decriminalized marijuana, and the legality of it really does depend on how much you have, how much of this marijuana are you smoking, and what you're using it for, because it is complicated, right? In small amounts, that's something that's, the law provides it, it's okay. But if you get into, possessing more quantities of marijuana, it's a little bit hard to justify that you're only using it for recreational use. And then also with now these new licensing for dispensaries and all of that. So those are things to take into account.
I can speak broadly to the issue in subsidized housing. So, we have in Illinois now, it's legal to possess a certain amount of cannabis, but we have tenants in subsidized housing that are still subject to federal regulations on controlled substances. So this is a clear racial justice issue because of the population of folks who are in subsidized housing. So you'd have in Chicago and Cook County, predominantly a group of people of color who would be subject to federal law, whereas state law in private housing would allow people to possess cannabis. So the Chicago Housing Authority has addressed this through a policy memo that kind of threads the needle between the federal and the state rules. But we take cases regularly about cannabis possession as an issue of termination. So those are cases that we would accept in the housing practice group because it's such an important racial justice issue that folks in subsidized housing would be subject to rules that most private housing wouldn't. The other thing that our Legal Aid Chicago would be concerned about is immigration consequences. Those are kind of the two groups that would still face major consequences for cannabis possession.
Can I also jump back in? And it really does. So with legalization of marijuana comes more regulation of it, right? And there are more ways to be in violation of those regulations and those rules. And, you know, when you think about the impact, right? Like, so again, this is the difference between the existence of a law and then how a law is actually applied. And we see that people of color are disproportionately still impacted by, you know, any type of ramifications from violating those regulations.
And Brendan, did you want to weigh in on marijuana too? It sounds like we could do a whole webinar just on marijuana possession. Please feel free.
Yeah, I mean, it just so happens that I represent both folks currently in the industry, folks trying to get in the industry, as well as seeing Chicago NORML. Just so people are clear on the specifics. The legal possession amounts in Illinois are 30 grams of flower if you're a resident, 15 if you're not, 500 milligrams of THC in edibles if you're a resident, 250 if you're not, 5 grams if it's a concentrate if you're a resident, 2.5 grams if you're not. That is supposed to be all that's required. You have several counties in the state, including Pulaski County, and a couple of counties out west. They're kind of the entry counties that are arresting people if they don't have actual dispensary packaging. That's not allowed. And as Natanya pointed out, in 2020 in Illinois, people who are arrested for marijuana, 17 times more likely to be arrested if you were Black than if you were white. They are still prosecuting marijuana cases. I did a sentencing on a marijuana case yesterday. Now it was a 100 key marijuana case, but at the same time, I'm representing clients. I represent THCC, which is sold for $45 million. So it's a real problem. But those are the actual limits in terms of marijuana. You're not supposed to. It doesn't matter. It's not supposed to matter whether you got it from a dispensary, but some jurisdictions are acting like it does.
Wonderful. Thanks so much, Brendan. And actually, Brendan or Natanya, this is a question that might be appropriate for you. So we've talked a little bit about arrest records and conviction records, but if someone makes a police report and names an alleged perpetrator, but no arrest is ever made, is there a record of the report that might impact that person named, that alleged perpetrator?
Brendan, do you want to go first?
Yeah, so unfortunately, the police really, at least in Chicago, really go on both sides of the right to privacy. There's actually no legal right to privacy if you're named. Theoretically, somebody could FOIA the report and get it. In Chicago, sometimes they redact, sometimes they don't. There are certain things that they have to redact in certain identifying information in terms of address, date of birth, social security. They often don't do that, but there's nothing that necessarily protects the name. And unfortunately, there is a burgeoning industry online of folks who are gathering police reports and just putting out information based on those police reports.
Yeah, and how this shows up for us is this could interfere with someone's ability to get licensing, especially for FOID cards or concealed carry. And this is another way that it can impact employment or being able to move up in employment, because a lot of our clients, they try to get jobs in security, and you really can't go too far in security without having that license.
Wonderful. So again, hopefully, Natanya, this is an easy one for you. Can a forgery conviction be sealed?
Oh dear.
I can help. So generally, a forgery conviction is not on the list of convictions that are prohibited from being sealed, right? So if it's an adult offense and the charge was forgery, and even if there was a conviction, there shouldn't be an issue with having it sealed. Now, of course, as Natanya mentioned earlier, everything is in the details. And so we can't guarantee that, yes, it'll definitely be sealed, because all of these remedies are discretionary. And of course, it depends on the amount of time that since the conviction has occurred for it to be eligible to be sealed. So my advice to you is to contact us, get your rap sheet so that we can look at it and we can provide the analysis of your record to see what you might be eligible for. So, but we often get these questions when we do presentations, which is that people are very, very focused on the nature of the offense. Is this a type of offense that can be sealed or expunged? And as Natanya pointed out in that report card slide, Illinois' laws on what can be expunged or sealed are actually really broad and relatively permissive. It often just comes down to, is it a conviction or is it was it dismissed or not a non-conviction, as she said. So, that's important for people to understand that many people are eligible for some type of relief for a lot of things that are on their record. Okay, just a few more questions. Natanya, can you talk a little bit about getting a rap sheet in terms of the cost and whether or not any of those rap sheets, including a juvenile rap sheet, might be available for free?
Absolutely. So it does cost to get an adult record, right? So if you go and typically we send our clients to 35th in Michigan, although our clients, they come from all over Cook County. But for our adult clients, we tell them that they have to get their rap sheet, and that involves a fingerprint scan, and those usually cost for adult records. And then what's important to understand is that juvenile records are different. So juvenile arrest records or rap sheets do not cost any money, but you have to request them separately from the adult criminal record. And most people don't do that because they don't know. You go in, you say, I'd like to get my rap sheet. Both of them require fingerprint scan. It's just that juvenile records are free and criminal records are not. And for us and with our work that we do, we actually get the juvenile rap sheets for someone. So they could walk in without having any of that stuff. And we actually do that legwork for them.
I think, Natanya, just to get specific, the cost of a rap sheet from the Chicago Police Department for your adult record is $16. And you still can go right now to get that rap sheet from CPD. The hours are reduced and they are requiring masking, but you can go right now and get that rap sheet if that's what you would like to do. So I think that's going to conclude the question and answer portion of this webinar.
Great, thank you so much, Melissa. Thanks to everyone for your really engaging questions and to our panelists who were so informative and kept the conversation going. So thanks to everyone for joining us and enjoy the rest of your afternoon.